Welcome to our podcast series where we provide expert insights into the evolving litigation landscape. This series is brought to you by the barristers at 4 New Square. I'm Richard O'Brien.
I'm Camilla Cockerill.
And I'm Anthony Jones.
Over 6 episodes, we'll be exploring key trends in group litigation and ESG matters. On 9th of April 2024, the European Court of Human Rights handed down judgment in Verein Klimaseniorinnen and Switzerland, or Klima. The applicants alleged that the respondent states' inaction on climate change had breached their rights under the European Convention. They were 4 female senior citizens and a representative organisation called Klimaseniorinnen. They argued that the impact of global warming on their health breached Articles 2 and 8 of the European Convention, both the right to life and the right to private and family life, respectively. Now, the court made some novel and divisive findings on standing, which there isn't time to go into today, but which practitioners in this area will need to know about, and I'd urge them to read what the judgment says on standing before advising clients on potential human rights claims concerning climate change. As to the meat of the claim, in a nutshell, the European Court's key finding was that Article 8 of the Convention had been violated because Switzerland had failed to take necessary measures to sufficiently reduce its greenhouse gas emissions in light of its capabilities and best available science. Breaking that down a bit, the court found that firstly, Article 8 encompasses a right to effective protection by the state from the serious adverse effects of climate change on an individual's life, health, well-being and quality of life. In this context, a contracting state has a positive duty to adopt and apply regulations and measures capable of mitigating the existing and potentially irreversible future effects of climate change. Now, this obligation was found to flow from the causal relationship between climate change and the enjoyment of convention rights, and the fact that the object and purpose of the convention, as an instrument for the protection of human rights, requires that its provisions must be interpreted and applied so as to guarantee rights that are practical and effective. So, what are a state's duties when it comes to setting aims and objectives? The answer is at paragraph 550 of the judgment, which is destined to become a very divisive, though important, paragraph. The European Court recognised that states have a margin of appreciation, that is, the deference that the European Court will afford to states when considering such questions. But when assessing whether a state has remained within its margin of appreciation, the European Court will examine whether the domestic authorities, be they legislative, executive or judicial, have had due regard to the need for 5 matters. Firstly, specifying a timeline for carbon neutrality and the overall carbon budget of the state. Secondly, setting out intermediate greenhouse gas emissions, reduction targets and pathways that are deemed capable in principle of meeting the overall national greenhouse gas reduction goals within the relevant timeframes undertaken in national policies. Thirdly, providing evidence of compliance with or efforts towards achieving the reduction targets. Fourthly, updating the targets in line with the best available evidence. And finally, acting in a timely and consistent manner when devising and implementing legislation and measures. Now, I said this judgment's likely to be divisive. It was highly controversial even within the court, and there is a very memorable dissenting judgment of the English judge, Judge ICJR. His dissent, which was in pretty strident terms, was to say that the majority had gone well beyond the permissible limits of evolutive interpretation in finding a violation of Article 8, and in doing so has tried to run before it could walk. One imagines some fairly awkward encounters in the judicial corridor after handing down this judgment. 2 main complaints that Judge ICJR had with the majority judgment in relation to the finding of article breach were first, what he considered the creation of a new right to protection from the effects of climate change, and second, the imposition of a new duty on states to adopt measures to mitigate those effects. Dealing with those points in turn, firstly, he described what he said was a new right to protection from the effects of climate change. I would argue that the suggestion that the courts created new substantive rights and duties overlooks the roots of the decisions in European court environmental jurisprudence and the long-standing application of the evolutive living instrument approach. Klima is best understood as an extension of well-established principles from key European court environmental cases, such as Honorildes and Turkey, where the court ruled that states must protect people from environmental risks like pollution and natural disasters under Article 2, and Lopez Ostra and Spain, where the court found that severe environmental pollution could violate the right to private and family life under Article 8. And these cases set the groundwork for Klima. In this sense, it's not a radical departure from existing jurisprudence, but is rooted in the court's established approach to environmental harms, reinforcing the idea that states must take reasonable steps to protect citizens from foreseeable risks. What's new here is the application of those principles to the global climate crisis. Secondly, Judge Eicher identified what he thought was a duty on states to adopt measures to mitigate effects of climate change. And it's true that one of the key criticisms levied at the decision in Klima is the prescriptiveness of some of the duties identified. How prescriptive are these measures in reality? The most onerous duty placed on states is, in essence, one to adopt a regulatory framework for climate change mitigation and to enforce that framework in good faith. However, although the Paris Agreement targets must inform the formulation of domestic policies, those targets are not enforced by the court, and the court specifies no minimum fair share of greenhouse gas emissions reductions which are required. So the net effect is that the court will still be very much a marginal actor in climate change policies and the enforcement of those policies. Unless states do not have any greenhouse gas reduction targets or choose not to enforce the targets they have at all, they're unlikely to exceed the margin of appreciation set by the Strasbourg Court. And it's important to note that Switzerland was a country whose policies were minimal in the extreme, and it's extreme facts like that often lead to judicial or jurisprudential developments like this. So in conclusion, forcefully articulated though Judge Eicher's objections are, I would argue that the European Court's conclusions on Article 8 in the climate change context are neither unorthodox nor unduly onerous on states.
As well as the determination by the European Court in Klima, one of the things that's interesting in climate litigation are the 3 advisory opinions that are either recently delivered or coming down the pipe. They're from the International Tribunal for the Law of the Sea, ITLOS, the Inter-American Court of Human Rights, and the International Court of Justice, the ICJ. Now, what's the political climate driving these cases? Well, small islands and developing countries have been sounding the alarm about climate change for years. They're at the forefront of the trouble with rising sea levels and with environmental destruction and extreme weather. But they lack the political and economic clout to make the big polluters take any serious action. So they're seeking, by asking international courts to intervene, to bypass the political forums in which they've not had any success. The requests for advisory opinions are essentially political, therefore, in nature. And while the court's rulings are not going to be binding because they're advisory, they are probably going to carry some real weight in the international community, and they'll probably become the sort of thing that people refer to in further climate negotiations for international treaties. So dealing first with the ITLOS case, setting the stage, in December of 2022, an organisation by the snappy title of the Commission of Small Island States on Climate Change and International Law reached out to ITLOS with a big question. What are the environmental obligations of countries under the UN Convention on the Law of the Sea, that's UNCLOS, when it comes to greenhouse gas emissions and the harm that these emissions cause to the marine environment? Now, as we all know, greenhouse gas emissions are one of the key drivers of climate change, and their effects on oceans, with the rising sea levels and warming waters, are getting more and more severe. The legal question in this advisory opinion is, can we consider that kind of damage as coming within the definition of marine pollution, which is what's regulated under UNCLOS? And if so, what responsibilities do signatories to UNCLOS have to stop the climate change which leads to that marine pollution? It was in May of this year, 2024, that ITLOS issued their historic opinion, finding that an accumulation of greenhouse gases and their emissions in the marine environment does constitute pollution for the purposes of UNCLOS Article 114. And that triggers the legal obligation of states under Article 194 to take what's called all necessary measures to control and prevent this kind of pollution. But what does all necessary measures actually mean? Unsurprisingly, it entails a margin of appreciation, but that margin is limited by the imposition of some objective factors of assessment. These include best available science, international rules and standards like those that are contained in the Paris Agreement, and the country's own means and capabilities. And it's that third one which I think is going to be particularly important in climate change litigation going forward. Because ITLOS explicitly stated that developed nations have a positive duty to assist developing nations, especially those that are most vulnerable to climate change, under the principle of what's called common but differentiated responsibilities, which is something that comes up in climate change agreements all the time. This assistance can be achieved through capacity building, scientific expertise, the share of technology, and other means. Countries are also, according to ITLOS, subject to what the tribunal called stringent due diligence. What the tribunal called best efforts are not going to be sufficient. States are expected to actually take steps to set up national systems, including legislation, enforcement mechanisms, with the aim of producing systems that are effective in controlling emissions and therefore protecting the marine environment and getting rid of the marine pollution, which is what's actionable under UNCLOS. So ITLOS was stressing that the standard of due diligence that states must exercise in relation to marine pollution from anthropogenic greenhouse gases needs to be very stringent and should be informed by the best available science. So that's ITLOS. Turning to the Inter-American Court, in January of 2023, Chile and Colombia filed a request with the Inter-American Court of Human Rights. They were asking the court to clarify the nature and the scope of the state's human rights obligations, so going back to essentially the same thing that was being argued in Klima in the European context. They were asking for clarification of the human rights obligations in the face of climate emergency and to provide some guidance to the measures that states have to adopt to ensure their compliance with international human rights and environmental law. In April of this year, 2024, the court heard two historic hearings in Brazil and Barbados, where it heard submissions from over 100 representatives of NGOs and individuals who'd been directly affected by climate change in what has been the most participatory advisory opinion proceedings in the history of the court. That opinion is expected to be handed down later this year, and we'll see what it says. The other advisory opinion proceedings are the ICJ proceedings. In 2021, the small island nation of Vanuatu launched a grassroots campaign calling on the ICJ to issue an advisory opinion on climate change. Now, that wasn't the first time that this had been attempted. About 10 years ago, Palau and the Marshall Islands tried the same thing, but they didn't have the political oomph to get it up and running. But this time, in 2023, the General Assembly did formally request an opinion from the ICJ, so that's before the court at the moment, and there have been a record-breaking number of interventions from, I think, 88 or so states. The ICJ is going to answer two questions. First, what are the obligations on states under international law to ensure the protections of the climate system and other parts of the environment from greenhouse gas emissions? And second, what are the legal consequences for states who cause significant harm in breach of those obligations? Now, the ICJ is expected to deliver its decision in 2025, so it will be able to be informed by both what ITLOS has said and what the Inter-American Court will say. It's going to be a crucial opportunity from the ICJ to provide a systematic and comprehensive interpretation of the international law on climate change. Doubtless it will be informed by what the European Court said in Klima as well, and it's eagerly awaited.
You mentioned that the ICJ's opinion will be coming last. and potentially going to be quite politically significant. It might be an unfair question, but do you have any sense of where the ICJ might come out in its advisory opinion?
Well, on the first question, which is what the obligations are, most commentators expect the ICJ to reiterate the existing voluntary obligations that parties have undertaken under mechanisms like the Paris Agreement, and probably to say that existing human rights obligations should be interpreted in light of the attempt to achieve those objectives. So I think it's probably going to be something pretty similar to what's been said before in terms of obligations. I think the most interesting question is what's going to happen on the second limb, which is what are the consequences of breaching those obligations. And commentators are probably right when they say that the ICJ is unlikely to impose anything too draconian on states, because it would just mean that everyone's in breach all the time, and what's the point of such an outcome? But I think probably there is going to be some grappling with this ITLOS idea of developing countries don't have as onerous obligations as developed countries, this sort of from each according to their means differential burden idea that ITLOS has developed. And I think that's probably something that the ICJ will endorse.
Thanks. So an interesting case I was involved in over the past year was the Chile and Colombia advisory opinion that Anthony touched on briefly. So as Anthony mentioned, Chile and Colombia put 20 quite wide-ranging questions to the Inter-American Court of Human Rights, essentially seeking guidance on states' obligations in the climate change context. And our submissions were looking at this issue through the quite focused prism of climate displacement. And the question that we were essentially answering was, what is the nature and scope of a state's obligations to individuals who've been displaced across international borders by climate change? And the submissions that we made were quite wide-ranging. So at risk of losing some of the nuance, I'm just going to pick up on three of what I think are the interesting arguments that we ran at the hearing in Brazil. So the first was that the international law principle of non-refoulement can be engaged by climate change. And the principle of non-refoulement at its core is this idea that states have an obligation not to return individuals to countries where they're at real risk of grave human rights violations. So that could be a threat to an individual's right to life, or a risk of torture or inhuman or degrading treatment. And we made that argument by reference to the jurisprudence of the UNHRC in its landmark decision in Tahiti Ota and New Zealand. In that case, the court held that where the adverse impacts of climate change in the home state reach a sufficient threshold of severity, that can, at least in principle, engage the right of non-refoulement, meaning that the receiving state has an obligation to grant international protection. One of the second points of interest is that we drew the court's attention to the expanded definition of refugee under the Cartagena Declaration, which is a regional Latin American instrument for the protection of refugees. Under the Cartagena Declaration, states have an obligation to grant refugee status to individuals who are fleeing circumstances which have seriously disturbed the public order. And what we said is that that definition is clearly capable in principle of being engaged by the climate emergency, again, where the impacts of climate change reach a sufficient threshold of severity so as to effectively endanger the operation of the home state. And we said that you can reach that conclusion just through orthodox principles of treaty interpretation, but it is also consistent with the UNHCR's climate change guidance and also the decisional practices of some of the international and domestic courts. One of the third submissions we made was the idea that states have a duty under international law to cooperate at a global level to respond to climate displacement. And we said that at a high level, that duty essentially breaks down into two parts. So there is a duty to negotiate in good faith to reach or to put in place new legislative frameworks and migratory pathways. But there's also a duty of burden sharing, and that's one which is alive to this principle of common but differentiated responsibilities that Anthony has touched on. So it's an idea that states have obligations commensurate with both their means and their causative role. So that's sort of a quick run through some of the arguments that we ran before the court, and we're now awaiting its guidance, which we're expecting at the end of this year.
Camilla, can I ask, how do you think the approach of the Inter-American Court is likely to differ from that of the other courts that Anthony mentioned?
Yeah, that's an interesting question. I think particularly because a lot of the discourse tends to focus on the way in which these advisory opinions before the international courts are sort of complementary. But I think there are maybe three quite important distinguishing factors about the Inter-American Court. The first is quite an obvious one, but it's its mandate and socio-political context. So it's a regional human rights court which enforces and interprets the American Convention of Human Rights predominantly in Latin America. And I think it's fair to say that it's generally thought of as quite a progressive court, one which tends to draw on a wide range of sources of international law to reach often quite an expansive conceptualization of the civil and political rights under the convention, which probably goes to the second linked point which Anthony mentioned, which is that the proceedings before the Inter-American Court are some of the most participatory, probably by far the most participatory of all the international tribunals. So, for example, at the hearings in Barbados and Brazil, the court heard very extensive testimony from indigenous groups, young activists, so children, and also scientists. And I think that's indicative of the fact that the court welcomes a very broad range of perspectives, which might potentially steer the opinion along quite creative paths. And I think a third point of distinction is less about the court itself, but the fact that the way in which the questions have been put to the court is quite different to the way in which the questions put to ITLOS and the ICJ were formulated. Firstly, because I think they're at least ostensibly less neutral, insofar as many of them presuppose the existence of an obligation and then go on to ask the court for guidance as to its scope. And secondly, they're far more granular and directive. So the Inter-American Court has been asked for guidance on a number of very specific issues, like, for example, the rights of environmental defenders. And I think that is potentially quite significant because even though it's open to the court to reformulate the questions that have been put to it, I think we know historically from these advisory opinions that the nature of the question that you're asking can be fairly significant in terms of the answer that you ultimately get. So I think that's all we have time for today. Many thanks, Richard and Anthony, for your insights. If you're watching on YouTube, don't forget to hit the subscribe button to stay updated for new episodes. You can find a link to our regular podcast series, 4 New Square Chambers in Brief, at the bottom of this video. For more expert insights, visit our website at 4newsquare.com.